I want to talk to you today about what's called alternative dispute resolution, or ADR. Now, that sounds complicated, but it really just means ways that you can use to avoid having to go to court, which everyone wants to do if they possibly can. Now, there are many ways, many methods of ADR, but I want to concentrate on three today, and those are mediation, collaborative law, and arbitration. So if I take them in that order, the first one is mediation, which is probably the one that's best known. And if you decide to go into mediation, then you and your ex-partner would go and meet with a trained third party whose job is not to be on either person's side, but is to provide an environment within which the two of you can talk and see if you can come up with solutions that you're both happy with. It's important to remember in mediation that the mediator can't give legal advice, and so you should continue to take legal advice from your solicitors as you go through the process to make sure that the solutions that you're considering and talking about are not going outside of what the court would consider to be a reasonable settlement in your case. If you do manage to reach agreement with your ex-partner on what you want to do, then the mediator will again tell both of you to get legal advice on the final proposals. And it's only if you're both still happy to go ahead after you've had that legal advice that the decision can be made finally and the settlement can be made into a final order by the court on the terms that you've discussed. The second kind of ADR that I'd like to talk about today is called collaborative law. And this differs from mediation in that your solicitors are involved much more up front in the negotiations from the outset and throughout. The way that collaborative works is that you and your ex-partner, both your solicitors, agree from the outset that they're going to try to find a solution to the problems that there are, and those problems can be relating to children or financial matters or both. And the agreement is that everyone is going to try to find a solution which is best for the whole family, and particularly best for any children. So it's not a case of one person and his or her solicitor trying desperately to get the best possible deal that they can for themselves, and the other side doing the same from the other direction. It's much more, as the word would suggest, a collaborative process, where you're trying to find solutions that are best for everyone. At the outset, the parties and their solicitors sign an agreement saying that they will work collaboratively. The solicitors agree that if it's not possible to find an agreement in the collaborative process, and if the couple have to go to court, then those solicitors who've been involved in the process will not be involved in the court proceedings. And that's very important because it helps to focus everyone's mind on making sure that the collaborative process works. The way that the process moves forward is that everything is done by way of what are called four-way meetings, where you and your ex-partner and both your solicitors are present. And the great advantage of that is that you have your solicitors in the room with you, and that means that they're there available not only to help guide discussions, but also to give legal advice as and when it's necessary, right then and there in the room at the time. The greatest thing about collaborative is that you and your ex-partner are in control, totally in control. If you decide between the two of you that you want to do something which is slightly outside what a court would normally do in a case of circumstances such as you and your partner have, then you can do that. It's entirely up to you. You are in control. So that's collaborative. The third type of ADR that I want to just touch on today is called arbitration. Now, this is more for people who have very significant problems which they find it's not possible to sort out either through mediation or through collaborative. And you'd think people in that situation would be left only with the choice of going to the court, but that's not the case. You can use arbitration. If you do that, you and your partner would agree that you are going to put your proposals to a trained third party who will then look at what each of you have to say and will then make a decision based on the law as it applies to your situation. situation. And you both agree that you will be bound by what the mediator says at the outset. Now, the advantage of arbitration is that it's much faster than having to go through the court system. And also, you have more control over the procedure that's used. You and your partner might decide you want to run it like a court hearing where your lawyers present evidence to the arbitrator on your behalf. Or you might decide that you want both of you simply to send in written submissions for the arbitrator to make his decision on. The decision is yours. You are in control. So that's it. A whistle-stop tour through ADR. I think the important point to take away is that where you and your ex-partner have problems that you need to resolve, you do not have to go to court. It is possible to sort things out in a different way using one or other of these ADR, alternative dispute resolution methods. And if you're able to do so, it will mean that you will avoid the stress of having to go through the court system, and hopefully you'll be able to retain maximum control over the outcome of what happens. So for more information about ADR or about any other family law problems, please get in touch with me or anyone else in the Clarke Willmott family team.